The next case that is set for oral argument this morning is Amy Otto, now known as Pekarik versus Stephen Otto. Both parties are present, so each side will have 15 minutes to present your arguments. Appellant may have up to 5 minutes for rebuttal if you would like to divide your time and use up to 5 minutes for rebuttal. We have read the briefs and are prepared to proceed if you are. If there are children involved in this, then we use initials and not names. Okay, so 15 minutes. I want to begin. And would you like to reserve any time?
Yes, I would.
How long would you like to reserve, sir?
Is it 5 minutes?
You can reserve up to 5 minutes. The last person reserved 3 minutes. That's totally up to you.
I'll say 5. I think it'll be less.
Okay, very good.
Thank you. May it please the court, Stephen Charles Otto. I will be representing myself today.
Very good.
Your Honors, numbers do not translate well to oral arguments, and that is why I did not request this hearing in my appellate brief. This appeal is really about a checkbook, Amy Pekarik's checkbook. It's a checkbook in which cash from Mr. D'Agostino was given to Amy Pekarik and deposited. Amy Pekarik has stated the purpose of the deposits were to pay for Mr. D'Agostino's employees. However, the majority of the deposits remain commingled in Ms. Pekarik's account. The deposits were significant. The retained deposits were significant, averaging about $2,400 per month. They exceeded the $2,000 pre-tax spousal support and represented about 43% of Ms. Pekarik's monthly expenses. During the period of time Mr. D'Agostino and Ms. Pekarik resided together, there were only 3 sources of deposits into this account. The direct paycheck deposits from her Lowe's employment, direct transfer deposits of spousal support, and cash deposits from Mr. D'Agostino. The records show, and Ms. Pekarik's testimony confirms this to be true. Now, my understanding is that cohabitation stands on 3 legs. Living together for a significant period of time, and shared expenses for day-to-day and financing. The court has previously found and reaffirmed the first 2 requirements. It is the third where I believe the court erred and then concluded that the cohabitation did not occur. All of Ms. Pekarik's daily, monthly expenses and finance bills flowed through this account. And by commingling Mr. D'Agostino's funds, they were sharing expenses. Your Honors, I ask this court to review and find the third leg of cohabitation has been established and that the previous court's ruling be reversed. Thank you.
Thank you, sir. You'll have 5 minutes for rebuttal. All right, good morning. You will have 15 minutes for the appellate.
Thank you. Steve, is this your pen?
Yes, thank you, sir.
You could just give me a second. I wasn't expecting to get up there that quick. I just said I had my materials. May it please the court, your honors, my name is Dean Kalovis. I am the attorney who represents and has represented Amy Pekarik throughout the pendency of her divorce and this appeal. I trust, of course, that as the court indicated earlier, you have all read the briefs. Mr. Otto is asking us to do is look at a 9-month period of check deposits and check withdrawals during a time when my client admittedly was living with a married man, but she didn't know at the time. So I would point out, as far as the third prong of the test that involves cohabitation, you have it, and I understand this isn't 100% dispositive, but one of the prongs is that the parties must, or the paramour must assume the obligations equivalent to those arising from a ceremonial marriage. This was clearly a case where this individual, who she was living with, he basically was using my client. He was funneling money through her account. He was paying employees there. He was disappearing on the weekends. Presumably, of course, had a lot to do with the fact that he was married. Ms. Pekarik testified specifically and emphatically at trial that she always paid the mortgage, she always paid the utilities, she always paid for basically everything that she had paid before this gentleman moved in, and everything she continued to pay after.
Was there any evidence that she was paying extra on the principal during this period of time, on that mortgage, for instance, or making any extraordinary payments?
There is no evidence of that. There's no evidence of that whatsoever. In fact, if you look, I mean, I understand the whole argument Mr. Otto has advanced in his brief. And I understand how he's looking at this number and looking at that number and just doing a straight math equation, but this isn't a straight math question we're talking about here. Right? He's trying to apply one concept of the law or one concept of logic and trying to apply it specifically to another concept of logic. And what we have, or another concept of law, what we have here is a situation where we're looking at 9 months of statements that were probably a couple of years before this case went to trial. My client, her specific recollection of what every dollar was deposited or withdrawn for probably wasn't perfect. But what I asked the court to look at, and what I pointed out in my brief, even for this 9-month period, if you look at how much was this in this account when these 9 months began, and how much was in this account when these 9 months ended, there was less in the account when it ended than there was when it began. The logic here that my client was receiving a $2,500 or $2,200 windfall each month, if you follow that out logically, after and I feel bad because I can't remember her boyfriend's name, so Mr. D'Agostino. After Mr. D'Agostino left, that would have been a catastrophic blow to my client's finances. She had the same bills after he left than she did when he came there. But it's not as though she just lost a $2,200 source of income and all of a sudden couldn't afford to pay anything. She continued to meet her expenses to the same degree that she had met them before, because in reality, she was paying the expenses the whole time. Am I going to sit here blanketly and say that, you know, there might not have been a dollar there, here, or a dollar there that she used from this gentleman to pay for something? No, I'm not asking, I'm not naive, nor am I asking the court to accept such a premise. But what I am saying is, there's no evidence whatsoever that anyone other than Amy paid the day-to-day expenses that she had always paid before, she paid during, and she paid after. The relationship itself, yes, the gentleman was staying there for a good amount of time, but as I stated earlier, this was a married man we're talking about, and she didn't even know he was a married man, and as soon as she found out, he was gone.
Counsel,
yes.
let me just stop you there, if you don't care. I assume, though, you're not trying to get this court to issue a proposition or a point of law that a married man or a married woman can't cohabitate with another person?
That's correct. I'm not asking anybody, and nor did I go that far in my brief as to say that. But what I believe it is, if somebody's married, when you get to the point where it's evidence to be considered when you talk about the fact that were these people, was this person assuming these responsibilities? Because in this particular instance, you know, the whole, again, you've all read it, and I've said it, and I don't want to keep repeating myself, but essentially Amy's account was something that this guy was funneling money through for one reason or another. He obviously was not an honorable individual, just by virtue of the fact of what he was doing, and he kept it from Amy. I'm pretty sure he kept it from his wife too. I'm going to go out on a limb there. But this was a situation where my client was essentially being used. She was a hardworking mother who she had, she was trying to take care of her daughter and son-in-law at the time. She was trying to help out with them. She maintained that relationship during and after the marriage. She assumed a lot of responsibility. She had horrible health problems, which she continues to have to some degree to this day, persistent chronic problems that she has worked through. What my client was, Your Honors, is simply, she's a hardworking woman. She was just trying to make the most and do what she could with her life and do what she could with her finances. And
regarding her finances, what is the timing of the time that she was not actually working due to her health concerns relative to when Mr. D'Agostino was putting money into the checking account?
I don't recall specifically that there was any evidence presented to the effect that that came during a period of time when these statements are being offered. As a matter of fact, if I do recall properly, Mr. Otto indicated in his brief that the sources of deposit into the account were in fact her money from Lowe's and her spousal support check and then additional money from Mr. D'Agostino. But if I'm understanding your question correctly, this wasn't a period of time where Mr. D'Agostino was providing all the money into the account and my client wasn't working. That I don't believe was raised on any level at any time. My client was not questioned about that, nor do I believe there was any evidence offered at trial to support that scenario. I would ask the bench at this time, because I've made my arguments that I can make in response to what Mr. Otto said, and I know you've read my brief, not to be out of inappropriate here, but do you have any questions, any of you, that I could address? Because that's what I'm more concerned about, other than reiterating what I already wrote down in my brief.
What about anything in regard to food or car or anything like that?
Well, I believe the statement of my client was that she paid for all that she didn't use any money from Mr. D'Agostino to pay any of that. As a matter of fact,
I know you said that, but we've mentioned, other things, like the major things.
well, it was in, let me see if I can, hold on one second. If you could, please, I'm sorry.
Oh, that's fine.
I mean, I'm just looking at my notes that I took from the trial transcript, and I don't recall specifically if I cited this in my brief or not, but little things I jotted down. Gave me money towards bills sometimes, a couple $100 here or there. That's what my client testified as to what she received from him. There certainly was not any evidence established that he had a pattern of paying any of her regular monthly bills. In fact, I think that Ms. Pekarik basically testified to the opposite, that she continued to pay everything that she would pay. Is there anything else, because this is, again, I don't want to just get up here and reread my brief to you folks, because you've already read it. And I'd rather spend my time addressing your concerns than hearing myself talk.
What of the argument that the motion was filed after the period of cohabitation? What of that timeliness argument?
Well, as I have always interpreted the filing of any motion, is that it's retroactive to the date of filing. Now, this particular motion was filed several months after the cohabitation concluded. So my argument to address that point would be that even, and I'm not abandoning anything else I've said about all this, but even if in fact there was a legitimate argument, by the time the motion was filed, the cohabitation or alleged cohabitation had ended already, because the motion was filed several months after the cohabitation had concluded.
Well, is it your argument then, if the motion was filed during the cohabitation and the court found that there was cohabitation, but then the cohabitation ended and we still have several months left on the term, is it your argument that she would have been able to retrieve that spousal support?
My understanding with how the language was written in the decree is that cohabitation was not stated in the decree that it was a grounds for automatic termination of the award. It was a circumstance that could be considered in modifying the award. So if we were in a scenario where that had happened and the court had reduced her spousal support, obviously this is a whole make-believe scenario, but I would have advised my client, had that happened, had she cohabitated and the court reduced her support, and then that source of help left, I would have said, well, you can try to file to modify. That's an interesting area of law, but I think that it would logically flow that if her income was reduced because of assistance from somewhere, if her order was reduced because of assistance, that it could be increased if that source of income left, because that's what it would be essentially, as a source of income.
So it's not like it was up in the term at the beginning where it just said marriage, not marriage or cohabitation. In one of if either party deceases, if.
Right, I'm pretty sure the language said that cohabitation would be a grounds to modify I'm like 99.999% sure. I know it didn't say terminate. I know it didn't say that. So, yeah, I would just look at it in that regard. But what Mr. D'Agostino brought with him that we can't overlook is he brought with him an enormous source of his own financial obligations. And there's just nothing honorable about what this gentleman did. And as I said, if we do a snapshot of the account before and a snapshot of the account after, my client didn't derive any benefit out of this. They didn't go on any vacations together. As you had asked earlier, her mortgage wasn't paid down on her house. Her car didn't get paid off. No big bill got paid off. There's no evidence any of that happened. It just, they continued for these 9 months. And keep in mind, all we have is 9 months here. We have 9 months. All that happened was that essentially whatever level she was above water prior to this time, that she stayed pretty much at that same level. She was the same person after this guy left that she was when he got there.
Council, we'll obviously look at everything ourselves, but on page 12 of the appellant's brief, it does say that it's a standard clause, spousal support shall terminate upon husband or wife's death, remarriage, or cohabitation.
Well, that's not what's in this decree.
Okay,
I'll
we'll look at it.
I'll hang on, just let me see one thing real fast. I know it's not in here. Okay, as far as the termination is concerned, all right, it's subsection D of the language that was used in the decree. It said, subject to the court's continuing jurisdiction as set forth below, spousal support shall be terminated upon the death of husband or wife, the remarriage of wife, or 102 months after its commencement date, whichever occurs first in time. That's the clause that addresses termination. Okay, nowhere in that clause does it say that cohabitation terminates the spousal support order. I will concede that is a factor that can be considered in modifying the order as is set forth in the decree, but it does not terminate it. Okay, anything else from anyone?
No other questions, so thank you for your argument.
Thank you guys, thank you very much for your attention. I do appreciate it.
Thank you. Mr. Otto, you've got 5 minutes if you'd like to use it.
Yes, thank you. I would just like to point out that they were residing together for 18 months. The reason why there's only 9 months of checking account was unfortunately, when this all began, both myself and Ms. Pekarik were supposed to provide all of our documentation from the time of the divorce up until the first trial, and there was a lot of
I don't know if I'm allowed to object or not, but this is...
Not really.
Okay, all right, okay.
Go ahead with it.
we just didn't have, we never got everything, so that's why we don't have 9 of the 18 months.
Were there any motions filed or any pleadings filed indicating?
No, sir, there was not.
Okay, so that's probably not going to be in the record, which we're limited to.
I think as far as what was discussed about paying for expenses, there's paying for it. But I think the key word in my opening statements were commingling of funds. And once that occurs, I think they were sharing expenses.
Do you dispute the argument that she was being used by this person to basically launder money through her account?
I have no comments about being used. You know, she was living in South Carolina, and at the time I was here in Ohio or had moved to California. I really, I'd be reading her mind to try to answer that question. As far as using the term laundering, what I would say is, given the significance of the deposits, I believe it should have been at least reported in her taxes. I think there's a $10,000 limit for gifts. So in a sense, I think she was out of the lane there financially. I have addressed the timing of filing the motion. I would only say that I guess the argument is not Ms. Pekarik's decision and actions to cohabitate, but I guess they're trying to influence your final decision as to when I documented her actions. I believe that once she began cohabitating, that was my understanding that would terminate the divorce decree.
Well, doesn't the entry say
And I believe that
may be modified? Doesn't say terminates, it may be modified if wife cohabitates tantamount to marriage. Doesn't say shall terminate,
Yes.
or may be terminated.
And I believe your honors have broad discretion in that matter. I will point out too in closing that I think we're 19 or 20 months away or of your jurisdiction in this matter, and that's approximately the amount of time that they did reside together. And I will just conclude by saying that I look forward to your decision. And regardless of the outcome, I would like to thank you for the unique opportunity to speak before this court today. Thank you.
Thank you very much. Thank you both for your presentations. The court will take the matter under advisement. The court will issue a decision in due course. Do we have a good address for you, Mr. Otto, or did you say you're in California now?
The Timberwood address or the P.O. box?
Do we have a good address? I suppose whatever address is on.
Yeah,
the
you should, he's been.
I've been receiving it at my residence.
Okay, very good. Well, because the reason I say that is the clerk of courts will mail a copy of the decision to both of you on the day it's released. And you can also check the Supreme Court of Ohio's website where the opinions are posted. Again, thank you both for your presentations today. We're going to take a